like take it into different directions. So your feedback will be very much appreciated. Um, my slides change. You see this change in the slide, right? Okay, I
Yeah,
believe.
it's okay.
Okay, so all actors in the field have been talking for some times about the need to that AI will be fair, ethical, and just. But what exactly it means, it remains an open question. And different disciplines have different explanations for what algorithmic fairness would look like. In the computer science literature in 2018, there was a prominent paper that identified 21 different notions of fairness. And each kind of paper that introduced a new notion spent quite a lot of time arguing why this notion of fairness is better than previously introduced notions. Now, when I talk about CS notions of fairness, I of course talk about mathematical equations that can quantify fairness. What I want to argue in this paper is that due to the complexity of the legal and the policy domain that algorithms are deployed in, there is no hierarchy between the notions, but rather each one of the notions is suitable for a different policy domain. And there is no superiority between them. They are just suitable for different legal and policy domains. Each legal and policy domain is need a notion of fairness that is tailored to its unique characteristics. There are three groups of fairness notions that I will address: individual fairness notions, group fairness notions, and notions based on causal reasoning. For each one, I will talk about some of their sub-notions also, and then I match each one of the sub-notions with suitable legal notion of fairness. So we begin with individual fairness, the first group. The focus of notions in this group is the individual. The idea is to be fair to the individual, and the legal principle that lie at the core of this presentation is equality before the law and individual justice. The first subnotion in this group is the unaware approach. The basis for this one, this notion, the legal basis of it, is the Equal Opportunity Clause lied in the 14th Amendment to the US Constitution. I should say that I will focus mainly on US law. And as I said in the beginning, I have thinking about different ways to kind of improve this article. So I would definitely be open to consider different legal notions of fairness as it's in like European laws or French law, for example. So the unaware approach, as I said, it's based in the 14th Amendment of the US Constitution, equal opportunity, and it perceives fairness as color blindness. This is the traditional way of viewing kind of equal opportunity, the fact that everyone should be treated equally before the law. Protected attributes such as race and gender should not be included, but other than that, everything else could be included. And so the law requires us to treat individuals, to link between individuals, the characteristics of individuals and the characteristics of the, for example, the crime, if we're talking about criminal justice. And this is the reason. However, we do know by now that color blindness doesn't work from a legal perspective. And also computationally, um, although we cannot include race or gender, there are many proxies that replace those. So this notion basically doesn't work for many cases. in attempt to still kind of match it with one policy domain where it could work, an example that I give in this paper is, for example, the marketing of a very kind of luxurious product. So if the group that we are targeting is kind of homogeneous, there is no problem of unfairness or discrimination, perhaps we can just use an individual fairness through unaware approach. A more developed notion of individual fairness is fairness through awareness. This one was introduced by a paper by Cynthia Dwork from 2011, Cynthia Dwork and colleague. Disclaimer, I do work with Cynthia in Harvard. And the idea of this notion is not to treat everyone equally, but to treat those that are similarly situated equally. Now, idea is that the regulation by its nature is not it seeks to differentiate between individuals, and we have to find the pairs of individuals within the data sets that we can compare. How we define these similarities? Using a mathematical metric that represents society's best guess at the time. The metric is developed by experts from different disciplines, and they can tell, for example, what are the variables that represent similarities. The question that they would ask is when it's legal to classify people and what is the ground for classification. So let me demonstrate by example how this notion will be implemented. We know that in the criminal justice, for example, Black defendants are way overrepresented compared to white defendants. So, and they are over-policed and over-judged. And we also know that prior crimes is one of the predictors to know if the individual will recidivate, will commit other crimes in the futures. So we can see, for example, an equation that say that a white defendant with 2 or 3 priors is similarly situated to a Black defendant with 5 priors, because we just know that Black people are being catched way more often. So it's not equal to compare 3 priors to 3 prior, but we're going to compare 3 to 5. Of course, you can claim that this is oversimplistic because priors is a very broad category, and a prior for homicide is not the same as having a prior for a minor crime. So that the metric will kind of go deeper and try to kind of categorize what are the types of priors that we compare, and how we define the similarities. So this notion is promising both legally and mathematically. However, it's hard to implement because it's very hard to identify these mathematical metrics that we want. And as I said, like, who said that 3 priors compared to 5? Maybe it's 4 to 6, maybe it's 3 to 4. Okay, so now we are going to move to the second group of notions of fairness, group fairness. This is by far the biggest category among the 3. It includes many sub-notions that the common denominator between them is that not all groups have the similar starting point, and that integrating the differences in the equations is a better way to mitigate unfairness. So we see here the groups that the individual belong to. We are trying to be fair toward the individuals by identifying the groups that they belong to and a little bit prioritizing them in a way. From the legal perspective, legal fairness notions are mean affirmative action. It's a civil mechanism that allows us to, as I said, prioritize certain groups in order to kind of compensate for historical discrimination. The first sub-notion in this group is decoupling. This notion calls for creating different algorithms for different groups. The idea is that the list of predictors and their weight vary across groups. So we need different algorithms that will represent this variant. And we have another example for that, also from the criminal justice. One of the algorithms used in the US, still being used in the US, is Compass. They have two versions of they predict the likelihood that a person will recidivate in the future. And they have two versions of the algorithm, the general Compass and women Compass women. And the idea is that women represent such a small minority in the criminal justice system that if they will be considered along with the general population of defenders, their unique characteristics will not be highlighted, will not be given enough weight. So campus women give more weight, for example, to past trauma, victimization, abuse, economical marginalization, things that are also considered in the general algorithm, but their weight is different. The question is that about this notion is that are we comfortable as a society having different algorithms for different groups? In a way that we have campus men and campus women, are we okay with having campus black and campus white? Should we have a different algorithm for people that are gay or transgenders, for example? I'm not sure that the answer will be yes. And what if a person also belongs to more than one group? In which algorithm we will use? Where would we place them? Now, I think that this approach can be used only in cases that the minority that we are talking about is so small, and that again that perhaps that we don't have this negative classification with separating the group into a certain treatment, giving them a certain treatment. So there is no the fact that they have campus men and campus women is not deemed illegal in the US, but I'm not sure that it will be possible to extend it to other groups. Second sub-notion here, group fairness, is statistical parity. The idea is that the marginalized group should receive the positive outcome in line with their percentage in the whole population. So if we have, let's say, 100 loans to grant as a bank, we should give 50 to men, 50 to women, because women represent 50% of society. But this notion, so there is an open question about what is the whole population that we are talking about. Are we talking the whole population in the world, in the county that we are operating in, the whole pool of applicants? This is one kind of open question. We have also conditional statistical parity, which is a specific case of statistical parity that would, claim in the loan example that, let's say, women and men between 30 and 40 years old that are employed should receive a similar treatment. Now, this notion is often dismissed quickly by computer scientists because the idea is that we are given a preference to a certain part of the society just because, just in order kind of to meet the numbers, but we are not taking the most qualified individuals. I want to claim that in cases where affirmative action is approved by the law, this notion could be actually very helpful. And I can illustrate that through an example from the hiring domain. So imagine that a manager of an IT company wants to hire several engineers, and they use an algorithm to narrow down the pool of applicants. They know that they don't have enough women in the company, so they use an algorithm that has calibrated on that takes into account fairness. One might claim that statistical parity is not a good notion of fairness to be supported in this algorithm because this notion will basically like recommend hiring certain number of women just because it has to, not because those women are the most qualified. However, this notion can be used to balance short and long-term goals. We know often that the reason why women engineers don't receive ads, don't uh, we know that women engineers receive 6 times less ads about jobs, potential jobs, compared to men engineers. And we also know that those ads are often worded in a very masculine way, so they kind of discourage women for applying. By putting the burden on the employer and saying, no, you have to use statistical parity because we have affirmative action in this domain of hiring, so you have to hire, it is definitely in the best interest of the employee, of the employer, to hire the most qualified women. So the algorithm, the statistical parity would not mean just to hire any woman. It would mean to put greater emphasis and finding the woman that should be hired in this case. Another sub-notion of group fairness is equal opportunity. This one calls for equalizing the true positives. So I want to give loans to the people that I know that will return it. Um, and this is a good notion of fairness. However, it shifts the focus from the hard cases where we have the false positives and false negative to the so-called easy cases. I know that there aren't any easy cases when we talk about outcomes that impact individuals' life, but yeah. So a notion that is very much linked to that, but developed the equal opportunity further, is equalize odds. And this one calls for equalizing the false positives and the false negatives. The idea is that there is no algorithm that predicts correctly in 100% of the cases. So this notion calls for equalizing the error rates that the algorithm makes. This is a good notion, however, it's complicated to achieve due to the following reasons. The problem with false negatives and false positives is that society values them differently. Sometimes false negatives are more expensive than false positives. For example, in testing for a certain type of cancer, on one hand, we cannot test the whole population, but false negatives mean that we are risking individual life. In criminal justice, we have to decide if we want to protect the public safety uh, or the individual justice. We probably want to do both. We want to be fair toward the individual, but we want to have also public safety. But where do we draw the line? How much, if we protect individual justice, there is a maxim that says that better 10 guilty men go free rather than one innocent man be jailed. So do we apply this one? Do we really think that 10 men should be is the correct price for public safety? Different policymakers will have different answer to the question. The error rate that our society is willing to tolerate is different, and lawyers and policymakers would often be reluctant from putting a number on the how this rate, how the balance between them should be served. Last subgroup notion that I want to address is calibration. It means that probabilities should carry semantic meaning. So it calls for equality in any given score. So if, again, criminal justice algorithm rank people on 5 scales, and people that are at the highest, riskiest scale to recidivate, they have a 0.9 probability to recidivate. If when we dig deeper into the data, we see that 95 of those who classified in this category are Black and 5% are white, only 5%, the judge might think that this is that any white person that is kind of fall into this category is not really risky, because anyway the percentage is so small. So lack of calibration means different aggregated probability for the minority groups. And lack of calibration also discourages trust and confidence in the algorithm if it's not calibrated on all the scores that it gives. Calibration is great, and equalized odds are both good. The problem is that mathematically, we cannot satisfy both of them at the same time, unless we have a perfect classifier, which never happens, as you probably, most of you know more than me, as you are more mathematical people. The last group category of notions of fairness is notions based on causal reasonings. Those notions developed because of two unique characteristics of machine learning. The first is the fact that correlation does not imply causation. So the variables that are taken into account do not necessarily cause the outcome. And because of that, we have less explainability. And those two characteristics lead to the fact that we are harming due process. We are not giving the individual the ability to appeal the decision and to understand the decision that is made in their case and to appeal it if needed. In causal reasoning-based notions, only the factors that it has been proven that they cause the outcome are considered. And the way to achieve a causal reasoning fairness is often by counterfactual fairness. From the legal perspective, we often use this notion to show discrimination. Counterfactual fairness means that we will assess for a certain individual what would happen if the protected attribute was replaced. So we will assess what would be if a certain woman applicant for loan is a man, or if a certain defendant is white, not black. So we replace one variable, which is the protected variable. The problem is that the protected attributes, including race and genders and other, cannot be manipulated easily, and they do not impact just one aspect of life. By changing them, we do not take into account the impact that those factors have on the broader life of the individual. So we don't necessarily achieve fairness just by replacing them. The conclusion from this part of the paper is that we basically cannot satisfy all notions of fairness. And the following example illustrates that very clearly. The campus, the algorithm that I mentioned before, I want to kind of highlight it a bit more now. And it's, as I said, it's an algorithm used in different stages of the criminal justice for predicting the likelihood that a defendant would recidivate. And it's developed by a private company, Northpoint, now is called Equivent. It scores individuals on a scale of 1 to 10. There's a news outlet, it's from 2016, it was a big story in the US where ProPublica news outlet conducted an investigation that showed that campus is biased because according to their data that they collected from a county in Florida, they show that Black defendant, they follow kind of the defendants 2 years after they have been released. And they showed that 42% of Black defendants were classified as high risk, even though they did not recidivate. And this mistake that the algorithm made happened only in 22% for white defendants. So the algorithm was classifying Black defendants as risky in twice as much as it did so for white defendants. And I have to highlight that wrongfully classifying people as risky. They did not recidivate. The argument between so Northpoint, they released their own investigation. They said, no, this doesn't show unfairness. We are actually pretty fair. If you look at the data, you see that in the 10 different categories of fairness, you see that we are calibrated. Each one of the each risk category from 1 to 10, you see that approximately 50-50 we have representation of Black and white, and it's calibrated on each group. So It's clear that the argument between ProPublica and Northpoint centers on a different definition of fairness. ProPublica supported the equal opportunity notion of fairness. They thought it's not fair that people who belong to the positive group are not really classified as so. And Northpoint, they supported more calibration. They say, well, we are calibrated. We are not allowed to take race into account by the law. So this is kind of the best we can do given the conditions. The thing is that none of the notion takes into account the very important fact that, as I said, the blacks are overrepresented in the system. And perhaps both notions are valid, but it is a legal question or a policy question, which one do we want to favor? And of course, we can think about applying not just those two notions of fairness that each one of this supports. We can also think about the other notions that I mentioned, like fairness through awareness or equalized odds, but each one would have its own limitation, as I mentioned. So what should we do about all this? How can we address all the limitations of each one of the notions? From the developer's perspective, I think what would be very important to do is to clarify their approach to fairness. Northpoint only published their own findings and the explanation of the algorithm and the fairness only after ProPublica conducted this investigation. Nobody knew before why Northpoint, as a private company, was using this particular notion of fairness. So showing what is the notion used, and even better, whether other notions were considered and what would have been the result if they were used is an important aspect that developers can focus on. There are now many tools for mitigating bias offered by different companies. Those could be used as a support mechanism. However, I think that they should be taken with a grain of salt because the way to mitigate bias in one domain, in medical domain, is not the same way to do that in the criminal justice. So it has to be really tailored to the domain that we're focusing on. And the second thing that developers could do is to have increased social and cultural understanding of the domain that they're working on. So there are two things here. There is to knowledge about what the algorithm is going to do, whom is it going to impact, what is the, like there is no algorithm in the world that can fix a broken system that has been historically broken for such a long time. So perhaps to understand the underlying factor of the unfairness that exists. And also, the second thing is that the different society will respond differently to different ethical dilemmas. There was a study from the MIT group that showed that for the automatic cars, different they kind of examined across the world. So they saw that different countries have different preferences. Like in Asian countries, people prefer to protect in case of accident the elderly, but in other countries prefer to protect the youngest. So to understand what is the differences of the society that the algorithm would be implemented in. And from the policymakers' perspective, what they should or can do is to clarify the laws and regulations. Now, this will not be easy at all because regulation is by default written in a very broad way in order to accommodate as many cases as possible and to be kind of technologically neutral. So, and in the law, we often have built-in room for discretion. We have discretion for the judge that decide the case. We also have the discretion for the prosecution that decide to bring the case, discretion that is given to the lawyer in a way to interpret a certain legal aspect. So narrowing down, perhaps we should decide here what we can or cannot automate. We perhaps can automate only the cases where we can pinpoint specific rules that can be translated into code, but we have to acknowledge that many rules will not be able to be translated. And the second thing, of course, for policymakers to keep into account in mind is auditing in all stages of the life cycle of the algorithm. And finally, the last thing to be considered both by policymakers and developers is to encourage interdisciplinarities. We have more and more kind of interdisciplinary initiatives of working together, people from different disciplines, and I believe this is also like the goal of the seminar in a way, this seminar. So here the idea is to honor the expertise that each representative bring to the table and find ways to work together. So to conclude, I'm sure many of you are aware of this quote by George Box that all models are wrong, but some are useful. What I hope I managed to convince you a little bit is that the most models are actually not bad. They're quite right, but it depends how we use them. I try to cover many aspects of the algorithmic fairness, different, the three main groups, and then some sub-notions in each group. And the conclusion, and also I have to say, I talked about different domains. I talk about criminal justice, about hiring, about loans. Those are also very broad. So perhaps if I'm sure a paper can be written about each one of those domains more deeply and to examine how they can be analyzed. But the point is that each notion can be suitable for a different domain. So it really depends on the characteristic of what we achieve, what we want to achieve in a particular case. Thank you very much, and I look forward to the discussion.
Thank you so much, Doaa, for your brilliant presentation, which raises many issues. So we are comfortable in time of discussion. Yeah. So let me check who asked the floor. Bon. Raja Shatila.
Thank you. Thank you. Doaa, this was really very enriching and exciting talk. Thank you very much, because you made so many points. We can spend a lot of time on discussing these issues. I have a few questions. I mean, it's not really questions, it's remarks or comments. I will go very quickly through them so you can have a global answer. So one issue for me is validation of the algorithms, because of course you can propose any approach, and you mentioned many, but how can we validate that this is correct? We lack ground truth. Maybe by definition, because of the difficulty to really define fairness, etc., as you have shown how much it's complex, validation isn't even possible. So I would like to hear about validation. How can we validate? Because if we don't validate, how can we trust the algorithm? The second point is about human oversight. So typically here, we are using algorithms and we are using them without any human oversight. I mean, this appears to be the case in many instances of the applications. So how does human oversight operate in these conditions? All the more that the interest of using such algorithms is to get rid of the human judge, actually, because we automate the process because a lot of data is there. Third point is about redress. How can people protest or say that they are not satisfied with this, and what means of redress do they have? Of course, it relates also to the explainability issue, but nevertheless, what means of redress? And finally, one question is about accountability. Who's accountable for the decision of the algorithm? So I have many other issues, but we don't have time. I'll stop here. Thank you very much.
Thank you very much.
Okay, thank you, Raja.
Can I?
Klein? Yeah.
Sure.
Yeah, please.
Okay, yeah. Well, really, thank you for those points. It's really, really great, and I will try to address one by one. So, the validation first, like, yeah, I think this is a very important point, and as I said, as I showed in the campus example, like usually the validation. The problem is that we don't validate it in advance. We validate it only when we have a problem, or actually there is like a validation in advance, but I think it's a mathematical, like usually a mathematical validation, because you are going to do some testing. I don't know if by validation and testing you mean the same thing. So we do a lot of testing in advance in order to make sure that the algorithm will perform the way we want, but we don't validate it on the notion of fairness that we want to adopt. So I think that, yeah, it's an important, like, to validate in advance. How we can do that, perhaps by trying, so, like, the discussion about the fairness is often happening. It's a topic that excites it has a great deal of excitement among computer scientists. It's I know so many groups that are working on new definitions of fairness and developing existing ones, because it seems like it's great. We can model something, and computer scientists like to model. And it seems like a problem that could kind of easily be modeled, because you change the equation a little bit, you tweak it here, you tweak it here. But at the end, as I said, there is zero discussion about which notion of fairness to use. And this is not a decision to be made by any computer scientist. This is a decision, perhaps the role of the engineer is to show what would be the outcome if we do this and this. We often have the algorithm as a ready-made, either an algorithm that is kind of off-the-shelf product that is being customized to the need of the specific need of the agency that is employing it. And I think this is a super important issue when you are talking about the public sector and algorithms that are deployed in the public sector. We have products that companies are targeting those agencies and trying to sell them their product by tweaking the existing product, literally, but without really showing. The idea is that we present algorithms as magic. We said, oh, you have a problem, let's automate it and we'll give you the final solution, but we don't have a discussion about how this magic is going to happen. So I think the validation is in that stage. I think in addressing different notions of fairness and each one of them and showing what would be the outcome. Human oversight, exactly related to the previous conclusion, that I think we often want to automate the whole process. We are kind of losing more and more confidence in the existing judges and public officers. We say that they are biased and they give decisions that are not neutral. So this is the reason why we have a lot of automation. I wrote another paper, this is my last chapter, about exactly discretion and the impact of the algorithm on what happened to the discretion of the people who were conducting this job before. And there my conclusion was that we often give up, as you correctly said, completely about the discretion, about human oversight. But this should not be the case. I mean, I think that we have more and more the notion that the algorithms should support and not replace human being. So we can automate the very clear rules that we can kind of identify from a very long process. I don't know, data analysis. Like scraping through a huge amount of data and flagging to me what are the factors that are good as predictors for criminality or for hiring. And then a human should assess, are these really the factors? If the algorithm said that the color eyes of the the candidate is a good predictor if he's going to be successful in the job. Are we going to take it? Probably not. So I'm completely against full automation, but rather more as an assistive method. And I try to show that more in details, as I said, in an algorithm that I examined in my last paper. That's more from the domain of welfare, but I exactly compare between two algorithms, one that did a full automation and one that automated only part of the process. And you can clearly see there how the difference in the implementation of both of them happened. The way to appeal the decision, I think it's really amazing how each question like feed into the next one, because if we have enough way to validate the outcome and if we have enough human oversight, then we will certainly be able to appeal the algorithmic outcome. But if we do not, it's harder. So as I said, I think that there should be a respect for the people who have been doing this job. Of course, bias, human bias is certainly there, and algorithms could help in that. But the ability to explain and appeal the decision depends on the person who is actually working with the algorithm, their ability to understand what the algorithm is doing, their ability to intervene when is needed and to say, no, actually, in this case, I think that the person should receive the benefits that they are entitled to, or actually there is a certain part of the law that was not correctly translated into the algorithm, because in those cases, we usually do give people the benefits that they know. And finally, the accountability is we talk a lot about the accountability of the developers, which should be a big part of it because of the fact that those algorithms have easily been kind of sold and adjusted without careful attention to the details. But also the accountability, yeah, I mean, I know I'm kind of like repeating myself, but if we have the human oversight and if we understand more about the algorithm, then the public officers that are doing this job will easily be able to be accountable for whatever decision that they are taking. So it's all kind of really a good, nice pyramids of if we solve one thing, we can lead to solving the other. But thank you for all those points.
Thank you. Thank you.
Okay, thank you, Doaa. So, Alexis Tsoukias et Morgane, Non, tu as baissé la main? Bon, Alexis, Morgane.
Okay, okay. Morning to everybody. Hi, Doaa. Sorry for arriving a little bit late. But I already know the paper of Doaa, so the first part I missed. I suppose it's the first part of the paper that I already read. Before making my remark, let me add some remarks on the one about validation that did Raja. Typically, validation in, let's say, in decision modeling is based on four, let's say, dimensions, which is conceptual validation, so whether we are using the appropriate concepts for what we are modeling, then logical validation, whether the logical consistency of the model is verified, then experimental validation, which is whether using experimental data the outcome is the expected one, and then what we call operational validation, which is when we use this model in the real world, whether it turns out the outcomes that have been expected. No, so this is how we try to, let's say, to verify a decision model in the literature, but also in practice. However, the topic of validation, no, as I express it, does not handle an issue which is of extreme importance, which is the legitimacy of a model to be used. No? Because we could have something which is valid in the sense that it does exactly what we would like to do, which is logically, conceptually consistent, that it turns out the outcome that we want to find. but nevertheless, it's not legitimate. No, and this is a very big topic. There have been tentatives in the literature to handle this issue of what does it mean providing legitimate decision advice. No, but it's still an open question in reality. No. Now, one of the things we need to consider when we talk about legitimacy is the purpose, no, for which we implement a decision support. Why I'm saying that? Because in reality, what we are talking here is not sorry, that was my phone calling. What we are talking here, even in the cases that Doaa presented, is not really algorithms that take decisions. It's algorithms that automatically compute recommendations. The Compass case, for instance, what the algorithm does is not deciding whether you are really a recidivist. No, it predicts a score which the judge is expected to use in order to make a decision whether you have you can access, let's say, a program of being conditionally free, etc., etc. No, and the same thing, for instance, for loans or for being hired. Typically, algorithms recommend something, but not really decide. Now, so the purpose of these algorithms is to construct a recommendation, a synthesis, no, for which the human decision maker is eased in doing his task. Certainly, there is an issue on whether the human is able to disagree with the recommendation of the algorithm, no, because most of the time, in most of the cases, this is not possible. So this is why it is extremely important to understand what is the purpose of these algorithms, what exactly, no, these algorithms are expected to provide in terms of support to the human decision maker. Now, let me make my remark, which is also a question, no, which is a twofold, no. In let's say fairness by awareness, no, which is based on the idea to treat similarly people which are similar, no, the idea of similarity is essentially based on demographic characteristics, no, which is a typically American perception, no, of clustering the population following demographic characteristics, no, sex, race, religion, age, residence, and things like that, no. Now, why we should cluster the population according to demographic characteristics? So, for which reason, no, we should accept being clustered, no, this way? And the second question, which is related to that one, is if we keep cluster the population using only this type of demographic characteristics, are we pursuing, let's say, as a drawback, ghettoing people? In the sense that if all black men are clustered together, no, it means that this becomes a block which is undistinguishable, no, because it's a cluster, no. But why all black men should be considered similar? So, and how dangerous it is to consider all black men or all white women similar, no? And this is my question. Thanks, Doaa. In any case, your papers are really very nice.
Thank you very much for those points. I agree a lot. I like the validation, kind of the four distinct points that you made in the beginning regarding validation. And I agree with a lot of what you said. in regard of the question about the fairness through awareness. So I will start from the second part of your question. Is it particularly in fairness through awareness, we are not really, I think, clustering everyone who belong to this group together, but we are trying to find one person who is the most similar to this person, and we see if they are treated like, if they are similarly situated. Now, the reason we cluster people through the demographic characteristics, I think, is because it's easier to compute things this way. These are variables that we are using for a long time. We don't have a problem in the US of collecting data about those variables. We are allowed to ask people questions, direct questions about those variables. So we have like a benchmark in which we can use to classify people. I'm very interested to know if you have any alternative, any different way to classify. I mean, in the end, we have to find some way to group, or if we don't give in the algorithm data about those characteristics, because, okay, so in the criminal justice, we build on a previous kind of data that we know. And before algorithms were introduced, we had Excel tables that people were using. So different versions of those algorithms have been there for a while. And people in criminology, law, in kind of many disciplines, have a very ongoing discussion about what are the predictors that we can use to predict criminality. And there are views, for example, Bernard Harcourt believed that we shouldn't take into account, for example, criminal history at all, because of the bias that is embodied in that. Other people, like Sonia Starr, believe that we shouldn't take into account demographic because, as you said, because individuals don't have any control over those data. Now, if we take everything out, we are literally left with nothing. In another, sorry for the shameless promotion all the time, but in another paper I worked on, particularly for criminal justice, I examined 8 different algorithms used in different jurisdictions, and the complexity of them varied. Most of them, the vast majority, had 0 machine learning component in them. But so there is a very famous algorithm that is used by the Arnold Foundation, and it only uses, I think, 5 variables. It's a very simple algorithm, very, very open, very interpretable, explainable. They use variables that are actually mainly criminal justice. They don't take into account, I think, a lot of demographic factors, because they want something that also you can easily kind of extract in the attempt. So there are attempts to kind of mitigate bias by using different factors. It's hard to tell, which one is better. I mean, like when we talk about demographic factors, so I mean, now nobody uses zip code anymore, but people use the age, and people use if you have an interview, so there are a lot of questions that even it's not like, the usual blocks of black, white, men, women. It's the questions are could be super biased, like asking you questions like Campus does. What are the if you know someone who have ever been in jail, or if someone from your family have been in jail, which is super like, related. So I don't have a clear, there is a big discussion, especially in criminal justice literature, about which type of variables is better, dynamic or static. The ones that you extract from an interview, the ones you extract from the demographic or the criminal justice, and the outcome of those studies vary. Some show that one and some show the other. I personally, I don't know. I mean, I personally prefer something that I can, like, I am personally not a big fan of using interviews in those cases, because in the interview, a lot of the interviewer can intervene a lot in kind of tweaking the question in a certain way, or writing down. There is a lot of discretion, so we lose the kind of notion of neutrality that the algorithm are supposed to boost. But in terms of telling you which one is better between the criminal justice or just normal demographic data, I don't know. There is no clear evidence in the literature. I wonder if you meant a different alternative that I haven't addressed.
Okay. Thank you, Doaa. Now, Morgan today with Associate Professor of Law, and then I'll take the floor for a couple of questions to Doaa. Morgan.
All right, thank you. Thank you for your thorough presentation. It was very clear and very interesting for me. I just have two remarks about your presentation. One is about law, discrimination, and statistics, because actually, I think one of the major goals of discrimination law is to fight against discriminating stereotypes. So the point is to fight against what's in the people's mind, especially the ones taking decisions, such as employers or judges. And the bias that we're using in law and the flaws actually we're using in law or in statistics, such as color blindness statistics or softwares or algorithms, is that we are focusing on the categories of the victims. And actually what we are fighting against, it's the categories in people's mind. But as we can't know what is in the people's mind, we do what we can do is to categorize victims. And that's a major flaw in law and in the statistics. And because, for instance, you mentioned the case of gay people. The key question is not to know if someone is gay or not, but the question is, do some people consider this one to be gay, and does discriminate this one because he thinks or she thinks he is gay or she is gay? And sometimes some people do consider heterosexual people as being gay, but actually they are not. And discrimination law is about fighting representation, not the category you do belong to. So that's my first remark. The second remark is just to make a comparison between US law and French law. I won't go into details on the debate about race, because we do not have the same law about that. But I just want to pinpoint something, particularly in the French labor law. In French labor law, we've got a specific discrimination ground, such as physical appearance. You cannot be discriminated in labor law because of your physical appearance, right? I don't think it does exist in the US, but you understand that physical appearance is too subjective a criteria to be put in numbers, in statistics. And all the few cases we've got about 10 cases in France so far. It's always because someone made a comment about the physical appearance of someone else, but it's always something subjective, this comment. And I don't know how you can put something so subjective into numbers. So that's my two remarks. Thank you.
Thank you very much. I think it's very interesting, this is a physical appearance. I'm curious to go to the case studies and to the law, to the cases, and to see how this is being interpreted. Yeah, I think I'll start from this question and then go to the first one. Yeah, I think that that kind of a bit links to what I was saying before to Alexis about the interviews and how we can translate, subjective comments to the algorithm. And I think we are entering a very kind of dangerous ground, because if we have too much subjective issues to quantify later on, we will have even harder time with the validation and the explainability and the accountability later on, because we are leaving too many open questions that to be kind of translated by the person who does the interview, or the person who takes the comment and have to later decide if it's discriminatory or not. But I mean, the law is designed in that way in many cases. I think, yeah, when we kind of decide what to automate, we should perhaps automate less and less areas where we have a lot of openness for subjectivity, in order to keep the room for the judges to kind of give their own interpretation of how this should be interpreted. Yeah, as I said, I'm very curious to know more about those subjects, and to make a case study out of that. I'll look into that. And as for your first question, uh, so it was about. Can you please repeat shortly the first question? It was
Yes.
about the stereotypes
Yes.
and yeah.
So, Klaus, it's I think the main goal in anti-discrimination law is to fight against stereotypes. So what's in people's mind, but you cannot know what is in people's mind. So you cannot, either in law or in statistics, you cannot put this in order, either in a decision or in statistics. So we're using something else. It's another way to address the issue, but it's not the right way, actually. It's to categorize the victims, whereas the true goal is to fight against the one who are taking the decision, what they got in their mind.
Yeah. Yeah, and yeah, thank you for repeating. True. I mean, it's I think some of the notions, like the fairness through awareness notion, is trying to kind of get into that a little bit, to examine. I mean, yeah, you mentioned the gay example, which is completely true. And today, even with mixed couples and mixed races, it's hard to know if someone identify as a black, as white, as I don't know, as a immigrant, as Muslim. So there are many things that we don't know if people identify with the classification that we give them. I think that some notions of fairness today are trying to like address that and see, but I mean, it's hard to quantify that, because if you have to do that based on like neutral kind of so-called characteristics. Yeah, and I don't know, how can you do that, like based on the data that the person give, for example, like not relying on like existing databases, but giving a person a questionnaire to fill, and based on that, like feeding the algorithm. That could be, I guess, one way. I'm curious it would be curious to examine if, instead of, we fill the algorithm with information about the individual based on those closed clusters, as Alexis said, about what we know about the individual, but we tell them to fill in a questionnaire and then feed that data. That would be an interesting thing to do. I know that in criminal justice, it's in some cases it happens, like as an alternative to interview, they do give people a paper that they have to fill, and based on that they feed this data into the algorithm. But there's also like an anti-stereotyping approach that also I think is important here to mention, that in some algorithms, so the goal is not to fight, discrimination per se, but to fight like the stereotype, to fight. So yeah, it's a certain kind of type of equality, to achieve a certain type of equality by fighting the stereotype. And yeah, I think it's an interesting approach to see how can we dig deeper into the information and not plan based on what we think, but based on what people actually perceive themselves. Very interesting. Thank you.
Okay, thank you. So I have two or three issues I'd like to raise. The first one concerns the boundary between individual and group fairness. I don't know if you agree with me on the fact that, for example, equal opportunity can be a relevant issue for individual fairness when there is a discussion about the just the fairness of outcomes, or for example the unaware approach or column-blind approach. If I take the famous case Rizzi versus De Stefano, which is a case in the of competition for promotion among the firemen in New Jersey, and the black firemen failed and did not succeed in this promotion, and so the authority cancelled the competition owing to its unfair outcome. And so the case was taken before the courts. And what the successful firemen were white argued is that the cancellation of the approach was affecting the equal opportunity concerning them. So it's the first question that the Rizzi versus De Stefano case makes me think about the boundary between individual and group fairness. The second point concerns causality versus correlation. Concerning employment, fair employment rules, in the US there's a rule set up by the Equal Employment Commission, which is a rule of 80%. So, which means that the selection rate of two groups must be close to 80%, if less of 80%. So it's for example, for 40%. It means that the chance of a minority, black or women or whatever you want, is 40% of the selection rate of the dominant group. And so this rule is discussed because it fails to establish to set up a causality between an employment practice or the way to conduct a hiring process and the outcome. And so what is interesting to see is that there's a debate before the courts in the US about the relevance of the 80% rule. Can it be the basis of a causal analysis or not? So the discussion on that. And besides the 80% rule, there's another practice which consists in statistical significant tests. which consists in trying to show that the outcome, so a lesser legislation rate for a minority, is not due to chance, is not due to hazard, but can be directly connected to the employment practice or the way the hiring process is made. So it's a practical dimension of the causality analysis, which I discovered in the American case, and I'd like to have your opinion about that. Third, I'll be short, briefly. If you take a legal concept like disparate impact, which has been set up in a federal regulation, so the idea is to measure the relative risk of protected group versus the unprotected group in terms of access to benefits or to a decision. And if you consider this legal concept, there's a huge literature in computer science trying to modelize disparate impact as a relevant dimension of the fairness discussion. And what the computer scientists do is that they take the disparate impact concept, they define it, and they consider it a useful tool to address equal outcomes between protected and unprotected groups. And by the other side, if you consider the legal concept, in fact, the legal concept is a dynamic one. It's a concept evolving with the judicial practice, with the way courts handle this concept. And it seems to me that there is a discrepancy between the concept of such as the computer scientists define it, and the dynamic concept in the field of law. So there's 3 points of discussion of your presentation. Thank you, Doaa.
Okay. Thank you very much. So I will combine your first and last question together because I think they're very related. So equal opportunity as the difference between individual and group fairness. Yes, I have been told that also different disciplines, like in computer science, for example, individual fairness is mainly fairness through awareness. But I think, so when I say, what I mean by saying individual fairness is notions that do not necessarily consider the group affiliation. And notions of fairness that, that basically aim to achieve justice or fairness for the individual, regardless of their group affiliation. Now, I think there is a bit of confusion in terms of equal opportunity. So there is equal opportunity as a notion that I discussed in the group fairness that was calling for equalizing the true positives, classifying the people that are that are deserving the group positive to be receiving actually the positive outcome. But there is equal opportunity as it's like part of the constitution, as in defining actually what is individual justice mean. So I see the confusion, in a way that that's using the term twice in a different meanings. Richie V. Di Stefano, so equal opportunity as part of the 14th Amendment indeed refers to equal opportunity to individuals. I think so. Okay, the group fairness part of equal opportunity is sometimes called equal accuracy. So you're right, I should have perhaps used this term better than equal opportunity, because equal opportunity, is a bit confusing. So to go to equal opportunity, Ricci Di Stefano, and now I'm kind of touching on your third question, because the significant legal aspect of Ricci v. Di Stefano is the distinction between the disparate impact and disparate treatment. Now, those policemen who did not get the test, did not succeed in the test, the claim was that, disparate impact means that the law is producing an outcome that could be discriminatory. The law is written in a way that is discriminatory to minority groups. And disparate treatment means that the law is neutral on its face, but it's implemented in a way that is causing a discrimination. And what Ricci v. Di Stefano meant is basically evolving the disparate impact to include another dimension, is disparate treatment. What Ricci v. Di Stefano did is to a little bit eliminate the disparate treatment theory, and to say that now what I want to focus on mainly is the disparate impact. So if the law itself is discriminatory, not its implementation. And this is a bit been kind of criticized a lot, because it narrows down like a big legal theory of disparate treatment, because many laws on their face are not discriminatory, but what matters is the implementation, how they're implemented in practice. And after Ricci, this becomes a harder theory to prove by the court. I have to say that it changes between disciplines. For example, in the housing domain, it's been the Supreme Court approved that disparate treatment exists, not just disparate impact. But so this is another level of complexity of my fairness typology. It's not just talking about the notions of fairness generally, saying, okay, disparate treatment theory would be good for this notion. It's saying about how the contextually it's been interpreted by the law, and in which domains the law said that we can use this theory or we cannot. So this is totally I think I evolved it a little bit in my after the paper has been published in my dissertation. I kind of touched on that more to clarify this point. Okay, and your second question about statistical significance. One second, I'm just checking my notes. Causality and correlation. And statistical significance. Yes, I think. No, one second. Did you mention the 80% rule, right?
Yeah, I did. Yeah. About the the fact that the 80% rule can be or not a causal analysis.
Yeah, I think that the 80% rule and the statistical significant, they're being used in different cases, not necessarily to, I think it's interesting to think that in terms of causality. I haven't thought about that. It's more for validating the algorithm. It's been used, I know that in employment and also in academical school admission, there is a similar rule. We always have what would be the chances of someone to be admitted. In terms of causality, we have it as a statement here that it's like the law, that it is the mathematical rule that should be followed. But so yeah, you can argue why it's 80, why it's not 79 or 82. I don't know if it really justify the causality, because the point with the causality is that is, I think, like less mathematical, is more counterfactual if it's causing the outcome. I haven't thought about it in causality terms. I will think about it more. Yeah.
In my opinion, it's a useful reference to evaluate the importance of the treatment of the different groups. It's not. It can't. It can be. It can be a causality. It shows the magnitude of the problem, and I doubt about its aptitude to support a causal analysis. Personally, so that's my. Okay. Thank you, Doaa.
Thank you very much.
Thank you very much.
Those were all very great questions.
Great questions.
Yeah, it was great. Thank you so much, Doaa, once again. So the next webinar will be in March, the March 2, about commitments to ethic commitments and commitments to fairness in the industry, with a presentation by Raja Shatila and then myself, if I yeah. Thank you. Have a good day.
Thank you, everyone.
Thank you.